class number 15 of our legal English course. This is going to be the final lesson in English. Today we'll be just going over a few interesting aspects of other countries with the common law system, just so we can highlight a few differences to help you in your own research should you work with those countries. So here I highlighted some of the main countries with the common law systems. I talked about this in one of the first lessons. We have Australia, South Africa, Canada, Ireland, India, New Zealand. New Zealand being interesting because it doesn't have a written constitution, like the UK has an unwritten constitution. But India and South Africa, it's hard to really classify them as common law countries. But for the sake of this course, I did. But you should know that there's a lot of influence from other, from other sources in those countries. From India, you have traditional Hindu law, and South Africa, South Africa is a republic, so it's not part of the Commonwealth. So it's really very different from from the other countries. In Ireland, also significant differences because it's a member of the European Union. So EU law does apply in Ireland. So like I said, virtually all the countries that were occupied or colonized by the United Kingdom, and that's a lot of countries, for a significant amount of time, will have some sort of common law system. But when we're dealing with maybe countries in Africa or Oceania, it's a lot of different systems. Uganda or Nigeria, there are elements of common law in those countries, but it is a very difficult research to make, and it really goes a lot beyond the scope of what we can provide in this lesson. So we're just going to be focusing on those 6 countries that I mentioned. So Australia, the first thing you have to know is that it has a written constitution like the United States, and it does have a Supreme Court which conducts judicial review based on that written constitution. So really it's close to American law. It also has the idea of barristers and solicitors, the barrister being the court lawyer and the solicitor being generally the out-of-court lawyer. So the Australia has a certain constitution. It also has a federalist system. Senate, the Australian Senate is not like the House of Lords. It does have effectively more power than the House of Lords, and they have a federation. So they have states and they also have territories. So it's not a unitary government like New Zealand or Ireland. Yeah. So barrister and solicitor, we've gone over that, but it's always good to repeat that. And here we have a case where I just wanted to show you. I read very little case law from these other countries because it was a little difficult to find, and we didn't really have a lot of time. I just wanted to show I just wanted you to see the Australian Supreme Court, adjudicating in accordance with the Australian Constitution. So basically saying, because the Australian Constitution says this, we have to act in a certain way. And they even do mention the American First Amendment. So just so you know that the United States and the United Kingdom do influence all the other common law countries. There was this idea here, that in this case here, in the High Court of Australia, the High Court of Australia decided that there was no right to a free legal representation. This is the case from the 1990s. And you see that usually when you sue the state in these common law countries, you can call it, the Queen or the Crown or the King, because the Queen or the King are the personification of the state, and this applies for all Commonwealth countries which have the British monarchy. So the Canada, Australia, United Kingdom, a lot of times the idea of king and queen is being used as synonym for the state. That was a decision of the Australian High Court. Here a little bit of relevant case law. It might be a little bit difficult to find. It's very easy to find decisions by the American Supreme Court, but decisions by the High Court of Australia and other bodies are a little bit harder to come about. So if you do want to have a starting point, this is a good recommendation, but please do your own research and go further than this if you're looking to work with Australian law. South Africa, you have a hybrid system with elements of civil law, because it used to be a Dutch colony, and they still speak, many people in South Africa, especially white people, speak a dialect, or really an offshoot of Dutch called Afrikaans. And that's one of the official languages spoken in South Africa. And you can see that they have this hybrid civil law, common law system. Usually, when countries have a hybrid system, civil law usually applies more to private matters, and common law more so to criminal matters. They do have a written constitution, which is the supreme law of the land. So that's something that we are familiar with. And advocate is someone that we use for trial lawyer. So he's my advocate. Advocate can be used as a sort of a synonym for the idea of a lawyer in any English-speaking country, but it's more common in South Africa. This is very important to keep in mind. South Africa has 11 official languages. You're going to find, I think, most cases, case law from South Africa can be found in English because it is one of the official languages. It is the language that's most common for government matters, but In addition to English, they have 10 other official languages. So you have Afrikaans, Zulu, Sesotho, and a bunch of other languages. And all of them have equal standing in the eyes of the South African Constitution. So it's not like English is the preferential language. You can use any one of those languages in court and as a lawyer. Here you see the Constitutional Court of South Africa adjudicating in accordance with the Constitution of South Africa, and the Constitution that had to be changed after apartheid ended in the early 1990s. Apartheid being this system of enforced segregation between white and black South Africans. So basically, they have their own Bill of Rights and they have their own constitutional protections, and they adjudicate based on that. That's why they have a constitutional court. Here, a little bit of relevant case law. It goes without saying. Please do your own research and go beyond this if you want to work with South African law. Canada, another country which has elements of a hybrid system, especially in Quebec. Quebec used to be a French colony. It speaks French. You can use both French and English in Canadian courts. And in Quebec specifically, you can find a lot of influence from Napoleonic law and French law in general. We do intend to make a legal French course at some point, so stay tuned for that. Yeah, so basically Canada also has two houses of parliament, an upper unelected house and a lower elected house. So they do have a lot of similarities with the UK in that respect, but they also have a huge influence from American law. In fact, there's a funny video of a criminal defendant recently arguing that he was protected by the First Amendment because the First Amendment protected free speech, and he was basically trying to use American law in a Canadian court, and the Canadian judges were unsure of what he meant. So barristers and solicitors, as we've explained, those terms are also used in Canada. The Crown, the Crown being the government or the state, usually you refer to that when it comes to the prosecution. So instead of saying the prosecution, you can say the Crown. And then the territories, like Canada, Canada has territories. These are, some regions of Canada which are very large in territory in our area, but have very few people. So they don't have a full provincial government. They just have a territorial government. And, in Nunavut, in the Northern and Western Territories, and Yukon, which are in the north of Canada, you have those territorial governments. So Section 35 rights, there are indigenous rights in Canada. There are indigenous nations in Canada. They speak their own languages and they have lived there for a very long time. And in relative isolation, there was a lot of human rights abuses perpetrated by the Canadian government against the indigenous population. Today, they have a certain autonomy in relation with the central government of Canada. Section 7 rights and Section 35 rights. Basically, the Canadian Constitution has its own constitutional protection and constitutional rights, which it observes and which it adjudicates with. So basically, the Supreme Court of Canada here was deciding on the matter of assisted suicide, whether or not it was constitutional to prohibit that. And it's an interesting case if you would like to read it. Basically, they ruled favorably in favor of the idea of assisted suicide for people who had very severe illnesses in this particular case. So here a little bit of relevant case law. Please read more case law in this. Ireland was a problem for me. I could find the case law, but I could not access it because it was all behind paywalls. So I could not really dig very deep into Irish law. But like I said, the most important thing to keep in mind in Ireland is that they speak Irish in addition to English. Even though English is really the language most people speak, Irish is one of the two official languages. In fact, it is the preferential language in Ireland. The Irish government, it is the national language of Ireland, so you can go to court and use the Irish language if you wish to. And the other thing that is extremely important in terms of Irish law is that they are a member of the EU. They use the euro, so all the statutory provisions of European law, if you're familiar with European law, do apply to Ireland. So those are, I think, the two things to keep in mind. They also use the idea of barristers and solicitors, and some older laws and some terms, particularly, which are in the Irish language, like the term taoiseach, I don't know how that's pronounced, refers to the Prime Minister and to Parliament in general. So you have to know that there are these terms that are in Irish, the Irish language, which is very different from English. But usually, pretty much all the legal officials and judges and lawyers in Ireland do speak English and communicate mostly in English. Because Ireland is closer, the legal system in Ireland is closer to Europe than it is to the UK or United States. They don't use juries for civil trials, just for criminal trials. Which it's more in line with the European Union, because the European Union, obviously based on continental European law, which doesn't have really a big role for jury trials. They do have a written constitution, which is also the supreme law of the land. They don't, and they got that constitution right after becoming independent from Britain in the early 20th century. And also, European law, very important. Here's a little bit of relevant case law. I was not able to find full copies of these cases. I was only able to find, the initial first pages. They always want you to pay. So that's the problem with, because the case law in the United States is easy to find, but in the other countries, I had some trouble. So I would recommend you look for an official source and try to find as much case law as you can, because I was really not able to learn a lot about the Irish legal system. India is going to be the weirdest of them all in terms of common law. It's very similar to our system. They have a long constitution. They have, a much greater idea of what constitutes a fundamental right than most common law countries. So it's closer to us in that sense, but they're very different from the United States and from the United Kingdom. Because, India is such a massive country, 1.4 or 1.5 billion people, which right now is the largest population. You have a lot of alternatives to going to court because, the courts are, they have too much to do because it's a lot of people and it's a huge country. So they have alternative forms of resolving conflict. In terms of languages, there are hundreds of languages that are spoken in India. 22 have some sort of official recognition, but the constitution does state that Hindi is the language that is to be promoted as a national language. Still, I mentioned it in our legal English class because the older cases, were written in English, even though today the tendency is for Hindi to become stronger and to effectively become the national language of India. But English is still very important because it was a British colony for a long time, and a lot of people speak English. Millions of people in India speak English. So you're still going to see English being used in court a lot. In fact, it's interesting because in the decision of Miranda versus Arizona, they actually mentioned an Indian case, and that's the only time of all the cases that I read from the American Supreme Court where they mentioned a case that was from a foreign country outside of the UK. So they do mention India in the Miranda versus Arizona case. And also, India has a written constitution. It's actually the largest constitution of any sovereign country. It's 30 times larger in terms of length than the United States Constitution. So there's a lot of stuff in there. A few things here. Lak Adalat, that's a type of conflict resolution. And we have local governments. India has this parliamentary system. At the federal and at the state level. India also has states and provinces with their own autonomy. And all of these places in India have huge populations. Even the smallest states have populations in the millions. So it's all of them. Have viable local governments. This is a very good decision, and I would recommend that you read it because it's not part of the mandatory reading, but it's a decision that I think reminds us of how we view the law and what we think is fair and what a constitution should entail. Because they do talk about a right to housing. And they're talking about squatters' rights. We remember when we talked about adverse possession in the US, how even American lawyers will refer to adverse possession as, theft, legalized theft, which to me was very strange. But India does not see that. They do recognize the constitutional right to housing, which, which offered protection to the people, being called squatters, which is a derogatory term, basically saying that they had to be protected and that there could be no stoppel, so they cannot be stopped against the Constitution. This is something that has been making the rounds in Brazil recently because of a wave of recent decisions by our Supreme Court about the constitutional adjudication being able to override stoppel. So if something is considered to be unconstitutional, that can undo the protection that you normally see from stoppel, and that is something that the Indian Supreme Court said in the 80s, and it's something that I think most people criticize, especially civil procedure experts. They think stoppel should be absolute, especially because in our constitution, the idea of stoppel and judicial stability is part of the constitution. And when I say stoppel here, I mean specifically the idea of coisa julgada, because stoppel has more than that meaning. There's multiple meanings in legal English. This is very interesting. I won't read it, but it's very nice if you want to look at the slide later, because it does reflect how we perceive the law and how we see the law as a way to address inequality and not just as a way to prevent government overreach. So here's a little bit of relevant case law. These Most of the cases are pretty long, but still you'd have to read a lot more case law than this to be able to understand Indian law, and it's going to be very, very complicated, I think, because it's very different from the other systems we studied. And then we'll top it off with New Zealand. New Zealand, the most interesting aspect of New Zealand law is that New Zealand does not have a written constitution. So like the UK, their constitution is unwritten, which means that they also have the idea of parliamentary supremacy. And something I didn't mention is all these countries that are part of the Commonwealth, which have the British monarch as their sovereign, they have something called the Governor General. And the Governor General basically represents the monarch in the Commonwealth, and bills that are approved by Parliament have to go to the Governor General, and he basically, or she, because it can be a man or a woman, they basically just always, confirm the bill. So really is more of a ceremonial position. There was a problem in the 1970s in Australia when the Australian Governor General was trying to interfere with the political system, and there was also something involving the British monarch, and that actually led to a constitutional crisis in Australia. But there are still a monarchy. Australia, New Zealand, and Canada are all monarchies. The power of the monarchy is vested in the Governor General, so he represents the monarch in those countries. So New Zealand, like all these other countries, they have these two tiers because they have a Maori minority population, which is the native population in New Zealand that was there before the Europeans came. They only arrived a few centuries before the Europeans, but they did arrive before the Europeans, and they were there before them. And the Maori language and Maori norms are observed and are given constitutional protections in New Zealand, even though they have an unwritten constitution. So yeah, you have many Maori terms here. I won't try to pronounce them, but basically, Maori is an official language of New Zealand. And if you look at New Zealand passport, you'll see translations to Maori, and you can use Maori in courts as well. Here we have a little bit of protection in terms of double jeopardy. They were talking about how double jeopardy functions differently in New Zealand. I won't go into too much detail. The case is in the analysis of the case by the Auckland University is in the drive if you want to read it. But basically, double jeopardy is something that is common in all common law jurisdictions, but that they do have different limitations and perceptions of it, but they all sort of, enforce the idea of protection against double jeopardy. And here, a more interesting case, I think, for our analysis here, Quilter versus Attorney General, basically saying we cannot legalize marriage between homosexual individuals using the court system because of parliamentary supremacy. So this stands in contrast with Obergefell versus Hodges, which is the decision from the US Supreme Court, because they were like, well, the 14th Amendment gives us the ability to legalize gay marriage without the approval of Congress, but here they said the opposite. There is no written constitution, and we have to observe parliamentary supremacy, so we will not do anything on this matter, and we will defer it to Parliament. So this illustrates well the differences between New Zealand and the other common law jurisdictions. A little bit of relevant case law, just so you can play around with New Zealand. Really, you're not going to learn a substantial amount of information about the New Zealand judicial system from this alone. You're going to have to do a lot more research. I always say that. All right, I'll see you in our next lesson, and until then.